So this should be our last discussion this semester of product liability, or at least our last lecture. We'll have some additional sort of discussion, hopefully. Uh, but the what I most recently went over were design defects and manufacturing defects, and we've been working on proving a defective condition. And so we were looking at a test for manufacturing defects. We were looking at a couple of tests regarding design defects. And we're going to look at another basis for finding a defective condition here, right? And then we're going to move on to talk about some of the other special doctrines and things we need to be aware of, at least from my perspective, to get us through the semester with regard to product liability. All right. So Jeffrey Johnson was taken to an emergency room. He was having an episode of atrial fibrillation, and he presented with a heart rhythm disorder. No problem. Dr. David Hahn was an experienced cardiologist. He used a defibrillator manufactured by Medtronic to deliver electric shocks to Johnson's heart. The defibrillator had a synchronous and an asynchronous mode. And it reverts to the asynchronous mode after each use. Hahn intended to deliver synchronized shocks. And those required him to select the synchronous mode for each shock that he delivered to Mr. Johnson. Hahn didn't read the device's instructions, all right? And Medtronic had provided these instructions both in the manual, which obviously is not there in the emergency room, and on the device itself. As a result, Dr. Hahn delivered one synchronous shock, and that was followed by 12 asynchronous shocks. You've seen Grey's Anatomy. You get it. You get the picture. So Johnson and his wife, Johnson was injured, of course. They filed a product liability suit against Medtronic, asserting that Medtronic had provided an inadequate warning about the defibrillator, and that the device, as a result, had a defective design. Remember I said that the defective design the warning is a part of the design, right? And in the fraud case, or the fraud hypothetical I came up with, right, because the weed whacker had an incorrect, fraudulent, right, instruction, right, kind of like a warning, right, also it's all part of the packaging, and because of that, it made the product, which otherwise would have worked on the proper foliage, it made the product defective, right? So here, the question becomes, it's sort of similar, right? Johnson, well, except for this is not a fraud. They're literally correct. You must select the right switch in order to deliver a synchronous shock after each shock. This was not what Dr. Hahn was familiar with, right? And the Missouri Appellate Court held that the Johnsons could not pursue a claim based on the inadequacy of Medtronic's warnings, but they could pursue a claim about the design defect, right? The court reasoned that in some cases, a manufacturer may be held liable where it chooses to warn of the danger rather than to preclude the danger by design, all right? So here, what they're saying is essentially that no warning can be adequate, right, in this case. It's not saying that they should have provided a better warning, right? In this case, the warning itself they don't have to pursue it. It's almost like he's saying you can't pursue an action based on an inadequate warning. But, in fact, right, that warning is evidence of the design defect itself. I know there's a shade of difference between that, what I just said a moment ago, because what I was focusing on was there's different perspectives that you can come from, right? The warning can be inadequate because it doesn't warn of a foreseeable danger, right? Or it could just simply be a foreseeable risk is if the foreseeable risk can be reduced or avoided, right, with instructions or warnings by the seller, maker, or distributor, then a warning is warranted. But in some cases, even the best warning is an inadequate warning. So I'll use this. I'll put this up here for you guys just to sort of see that for a second. It'll be in the PowerPoint. So an inadequate warning renders the product not reasonably safe, and that inadequate warning, every person in the commercial chain that gets that product to the consumer or end user is responsible, right? So all sellers in the commerce chain must warn of danger, e.g. foreseeable misuse, all right? There is, however, no need to warn of obvious risks just as in torts. No need to warn of obvious risks. Obvious risks and dangers are your own responsibility. For example, in torts, I think I said when we were first starting out, I don't have to tell you if I'm selling you a knife that the knife is sharp. You should assume that the knife is sharp, right? If the handle, however, is sharp and the handle cuts me, right, then obviously that is another problem entirely. It's probably a design defect, but certainly without a warning, it's a defective product. All right. A couple of other things I wanted to pay attention to in the course of this. With regard to warnings in particular, you have to be aware that there are still other laws that might be in play. So there are still constitutional limitations. So, for example, a case can be based on an inadequate warning. Generally, this is going to be a state law case. California had a law that imposed restrictions on labeling requirements on the sale of violent video games. I've used this as, I think I just used this one. In the constitutional exam, right? Although the video game industry had adopted a voluntary rating system for games, the legislators deemed those labels inadequate, right? So Video Software Dealers Association and Entertainment Software Association immediately filed suit in federal court to invalidate the law because it would have led to product liability, right, if they didn't conform, or it would have forced them to speak. If it's forcing them to speak, what does that implicate? Commercial speech. I know you had it right on the tip of your tongue, but since I can't see your hands raised up earnestly, I'll just go ahead and say it implicates commercial speech. So in addition to having to deal with the nature of what that warning would or would not do to that product, you also have to deal with the commercial speech and deal with the substantial or important government interest, right? Plus, goes no further, the necessary and directly advances that interest, right? So in this case, example 5.8, if you want to take a look, they basically determined that the California law had to be struck down. The court found that the definition of a violent video game in California's law was unconstitutionally vague and violated the First Amendment's guarantee of free speech, right? So from a statutory standpoint, if they were to have said, for example, games which depict certain acts, right, and they were very specific, right, games which depict mutilation, dismemberment, sexual violence, there are ways that California could have created a stronger law. But this is just to be aware that all of these laws, anything we've studied and anything that we may study and is going to have constitutional implications, certainly here. Other things that we need to be aware of. Market share liability. Market share liability involves cases where it may not be possible to determine the exact party that manufactured a defective product. And remember I said you must prove the defective product, right? You must prove that the defendant manufactured a defective product, right? For the defendant to have manufactured the defective product, you must know that they manufactured that product. In some cases, widgets, screws, commodified products and goods, that may be difficult to prove that an injury was made by a particular person, company / defendant type entity, right? If you make a good argument, courts have at times, right, dropped this requirement when there is no way to prove that the widget that caused your horrible physical harm or property damage was made by a particular manufacturer. We call this concept market share liability. And so in this, the court can basically get its hands on, theoretically, all of the people who participate in that market that are within its jurisdiction, right, and hold them responsible for a percentage of the plaintiff's damages that are basically equal to a percentage of their market share. And the example in the book is the Suffolk County Water Authority at 5.9, and they supplied water, Suffolk County, New York. They discovered a toxic chemical used by dry cleaners and others. It was called perchloroethylene, or PCE. I hope I pronounced that correctly. It's like my fourth time over it. But it's present in the local, so this dry cleaning chemical is present in the local water. They filed a product liability suit against Dow Chemical and other companies that manufactured and distributed the PCE. Dow wanted to dismiss the case in a motion to dismiss for failure to state a claim, as we've talked about way back in Chapter 3. Since the Water Authority could not identify each defendant whose allegedly defective chemical caused the water contamination. Because once the PCE is sold by chemical manufacturers, Dow being among the largest, if not the largest, it is no longer able to be determined once it's been used, right? The soap's out of the box. Not really so, but whatever. It's already been used. There's no way to determine who made that particular chemical, right? As opposed to dismissing the action, Suffolk County State Court decided to let it continue, holding that the Water Authority's allegations were sufficient to invoke, in this case, a form of market share liability, all right? And this means that there has to be discovery to figure out certain facts that might make it possible to determine not just Dow's share of the overall chemical market, but specifically for PCE, and not just that, because for their defense, they're going to want to limit as much as possible. They're going to want to limit it to who's distributing to people who might have caused that chemical to end up in some fashion in Suffolk County's water, right? Under market share liability, the burden of identification shifts to the defendant if the plaintiff establishes a prima facie case on every element of the claim except identification of Dow Chemical or a specific defendant as the polluter or the party who is responsible for the dissemination of that chemical. And as a reminder, I know you don't have your Black's Law Dictionary sitting right beside you, although you should. But a prima facie case is basically a case that's basically been established with all of the basic elements, or as the book says, presented sufficient allegations for a claim to go forward. So there are enough generally applicable principles, right, plugged into the complaint to be able to maintain that complaint. In addition, I've noted that the entire chain of commerce is responsible in strict liability if the product was sold by them in a defective condition and the other portions of the strict liability rule are met. And then we've got here a list of defenses that I will go over briefly because I'm going over my usual amount of time in order to wrap this up. But defenses to product liability. First one is preemption, right? There's a couple of examples of preemptive type arguments here. Case example 5.12, the United States Supreme Court, Rigel versus Medtronic. A man sought to sue because of a medical device, a balloon catheter, and because recovery was purely statutory, because the process for design and approval of this device was purely statutory, right? It's not Medtronic's fault for that design defect, because the U.S. Food and Drug Administration has preempted their ability to make alterations and make their own. They can make choices about design, but they all have to be approved by the U.S. Food and Drug Administration, right? So that would preempt the injured party's claim that they should be able to recover from Medtronic for the fact that that design is faulty, right, or allegedly faulty. The other example appears near the beginning of the case, near the beginning of the product liability chapter, and that's Brushewitz versus Wyeth. It's a text box, so it's case 5.1. It's a fully brief case, and in this case, the government provided a trust fund under a statute to provide for recovery for persons, generally young infants or toddlers, who are injured due to a vaccine-related injury, such as a severe allergy, unknown to the doctor at the time administered, right? And the case is interesting. The party was denied their original claim, and as one often does when the federal government denies a claim, they try to move over and have that looked at the federal court, the Article 3 court level. And they ruled that the entire recovery and the entire process is dictated by statute. And due process was received, and so there is no case. They can't bring that case. That is preemption, again, where federal law displaces something like a state law or some private right in this case, as opposed to being able to pursue that case in court or in state law. All right, so that is preemption. The others, assumption of risk, works basically the same way as it did when we discussed it in torts. All right, so Savannah Bowles became a customer at Executive Tans. She signed a contract. One clause stated that signers use the company's tanning booths at their own risk. It also released the manufacturer and others from liability for any injuries. All right. Her fingers were partially amputated when they came into contact with the tanning booth's fan. Bowles sued the manufacturer, claiming strict product liability. The Colorado Supreme Court held that assumption of risk was not applicable because strict product liability is driven by public policy considerations. The theory focuses on the nature of the product rather than the conduct of either the manufacturer or the person involved. You cannot assume the risk of a product for which the defendant is strictly liable. Now, assumption of risk will still work in negligence cases, however, just as it does in tort cases, other tort cases, right? But again, you still have to have the plaintiffs knowing, meaning they knew and appreciated the risk, and voluntary, meaning they did it because they wanted to, or because they certainly affirmed not under duress, knowing and voluntary assumption of that risk, right? But it's not going to work with strict liability. That's a good thing to be sort of looking out for, right, in a fact pattern, right? So the plaintiff says, assumption of risk, right? And the defendant were to say assumption of risk is offense, and the plaintiff were to say, well, no, we're not arguing negligence. We've got all 6 elements of strict liability, right? Then you don't necessarily have to deal with that area of proof, right? Because it's not a strict negligence case. All right. Product misuse. Again, this is something that will sound in some of the concepts that we talked about in torts. It's a new concept, but product misuse means that there is it's similar to assumption of risk. You could say it displaces assumption of risk in some respects. For example, in strict liability, you could still have product misuse, which does involve you're choosing to take a risk, right? but certainly doesn't require, a knowing involuntary assumption, right? It's the flip side of that, right? So David Schultz developed popcorn lung, which is a bronchiolitis obliterans, from consuming multiple bags of microwave popcorn daily for several years. When he filed suit against the manufacturers of the popcorn and butter flavorings, the defendant asked the court for summary judgment in their favor. The court denied the defendant's motion and found that the manufacturer has a duty to warn of dangers associated with reasonably foreseeable product misuses of a product. If it is foreseeable that a person might consume several bags of popcorn a day, then the manufacturer might have to warn users about the potential health risks associated with doing so. All right, so that's a caveat. A person who misuses a product, right, will not be able to recover. Right, so if I stand on top of the chair, and I'm dancing on top of the chair, and the chair had a defective bolt, and the bolt gives way, and I misuse the product, right, I can still, I can't recover because I'm not using that product in the way I'm dancing on the chair, right? And that's not necessarily a foreseeable. That would not be a foreseeable misuse, right? So product misuse only applies in the strict liabilities. In the product liabilities sense, if there is not a foreseeable misuse. All right. If the misuse is foreseeable, the seller may have to take steps to abate that potential misuse. Again, there's also comparative negligence, which we studied in torts, which reduces the plaintiff's recovery by the amount of plaintiff's own negligence. Commonly known dangers associated with certain products, such as sharp knives, right, don't have to be warned of and do not form a defect, right, if your knife is sharp. And if one is a knowledgeable user, this brings us to our last really substantive defense. Statute of limitations is, but for this one. So the parents of a group of teenagers who have become overweight and developed health problems filed a product liability suit against McDonald's. The plaintiffs claimed that the well-known fast food chain should be liable for failing to warn customers of the adverse health effects of eating its food products. The court rejected this claim, however, and they basically based it on McDonald's well-crafted, knowledgeable user defense, right? It's well known that food at McDonald's contains high levels of cholesterol, fat, salt, sugar, and other sundries, and is therefore unhealthy, right? In the court's opinion, and they thwarted numerous lawsuits against other similar restaurants by pointing this out. If consumers know or reasonably should know the potential ill health effects of eating at McDonald's, they cannot blame McDonald's if they nonetheless choose to satiate their appetite with a surfeit of supersized McDonald's products. All right, and surfeit just means an excess. All right, so they're knowledgeable users of McDonald's, so they actually can't recover under product liability. That's different from the hot coffee case. I hope you guys see that, right? Or you should have seen that if you've completed last week's assignments. If you haven't done that one, take a look at that. So the last one are statutes of limitations and repose. So a statute of limitations restricts the time period in which a plaintiff may bring a case. Some states also have a statute of repose, which place an outer time limit on product liability actions that say that if you've been injured and you wait a certain amount of time, even if it's within the statute of limitations, right? We feel that you should have filed earlier, right? Statute of repose may require that claims be brought within 12 years from the date of sale or manufacture of the defective product, right? If the plaintiff does not bring an action before the prescribed period expires, the seller cannot be held liable, right? All right, so this will bring us to the end. I have two assignments that go with this ending to our exploration of product liability. Please also respond with any questions, concerns, emails, things that I can sort of clarify, because I can do additional work on this to help flesh it out. Right. The next area that we will cover is we are going to begin this week our exploration of intellectual property. All right. The assignments for strict liability will be due this week, and the assignments for intellectual property will begin being due in the following. All right. Thank you guys so much for your time, and I hope everyone is doing well, and look forward to seeing you next time.